Constitutional limitations on power of Congress to enact penal laws. The constitutional limitations on power of Congress to enact penal laws are as follows. Number 1. Equal protection. 2. Due process. 3. Non-imposition of cruel and unusual punishment or excessive fine. 4. Bill of attainder. And 5. Ex post facto law. Equal Protection Clause. The Equal Protection Clause simply means that the law must treat equally persons or properties similarly situated with respect to the conferment of rights or imposition of obligations. Due Process Clause. Due process simply means basic fairness and adequate justice. It is an embodiment of the sporting idea of fair play. It requires that the law in depriving a person his life, liberty, or property must be fair and reasonable, that a person whose life, liberty, or property it is at stake of being deprived in a case must be given the opportunity to be heard and afforded all rights to which he is entitled. Number 3. Non-imposition of cruel and unusual penalty or excessive fine. A criminal who commits the most heinous crime is still a human being. Though he deserves to be punished for committing a crime, the government in doing so should not put him in a degrading and inhumane situation. The Code of Kalantao, which punished an offender by death through bite of ants or mutilation of arms, would not pass the constitutional standard on imposition of penalty. Accused was convicted for violation of RA number 8282 for his failure to remit SSS contributions of his employees and was sentenced to suffer up to 20 years of reclusion temporal. The penalty is excessive since he already paid his delinquent contribution. Under Article 5 of the Revised Penal Code, the courts are bound to apply the law as it is and to impose the proper penalty, no matter how harsh it may be. The same provision, however, gives the court the discretion to recommend to the President actions it deems appropriate, but are beyond its power when it considers the penalty imposed as excessive. Although an accused is convicted under a special penal law, the court is not precluded from giving the Revised Penal Code supplementary application in light of Article 10 of the same code. Prohibition on the imposition of death penalty. RA 9346. The Constitution does not abolish death penalty. The imposition of death penalty is merely suspended. Upon the effectivity of the Constitution, it is incumbent upon Congress to immediately pass a law defining heinous crimes and imposing death penalty if there is a compelling reason to do so. It is not enough that the crime is heinous to legislate for the imposition of death penalty. In addition, death penalty can only be imposed for a compelling reason. In 1993, Congress passed RA number 7659, restoring death penalty for heinous crimes such as qualified rape, murder, robbery with homicide, etc. Leo Echagray, who was convicted for raping his daughter, was the first person executed by lethal injection under RA number 7659. His execution sparked a heated debate on the morality of the imposition of death penalty. In 2006, the penal aspect of RA 7659 has been repealed by RA 9346, which prohibits the imposition of death penalty. Number 4. Bill of Attainder. Bill of Attainder is a legislation that inflicts punishment on an individual without a judicial trial. In passing a Bill of Attainder, the legislature in effect exercises judicial power in disregard of the doctrine of separation of power. Number 5. Ex post facto law. An ex post facto law is a law which retroactively affects that right or condition of an accused who committed a crime prior to its effectivity. Lifted from 2015 bar. Felonies. Crimes are acts or omissions punishable by law. If the crimes are punishable under the Revised Penal Code, they are called felonies. If they are punishable under special laws, they are called offenses. However, offenses are now being used to refer to crimes in general. Crimes may be intentional or culpable. If it is intentionally committed, it is described as intentional crime. If it is committed through recklessness or negligence, it is called culpable crime. Intentional crime is classified either as malum in se or malum prohibitum. Acts and omissions punishable by the revised penal code are felonies or delitos. Felonies are committed not only by means of deceit or dolo, but also by means of fault or culpa. According to Luis B. Reyes, the word deceit in Article 3 is not the proper translation of the word dolo. Dolus is equivalent to malice, which is intent to do an injury to another. There is deceit or malice when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Elements of international felony. There are two elements of an international felony: criminal act and criminal intent. Criminal act, or actus reus, is required to be committed to consummate a felony. To identify the criminal act, one must consider the verb in the provision defining a felony. In Article 249 of the Revised Penal Code, the verb used in defining homicide is shall kill. Hence, the criminal act is homicide is killing. Killing the victim consummates the crime. Mode of commission. Criminal act, the commission of which is necessary to consummate the crime, should not be confused with the criminal mode of commission. In Article 294 of the Code, the criminal act is robbery. In robbery is the taking of personal property, while the mode of commission is violence or intimidation. Employment of violence or intimidation to take the personal property is not enough to consummate the crime. Without actual taking, the offender is only liable for attempted robbery for employing violence or intimidation to take property. Criminal intent. To consummate the crime, the criminal act must be accompanied with the required criminal intent, since it is a basic rule that an act is not criminal unless the mind of the actor is criminal. Criminal intent is classified into general criminal intent and specific criminal intent. Specific criminal intent is found in Book 2 of the Code. Specific intent is either express or implied. Express criminal intent is expressly stated in Book 2, Article 308 of the Code, expressly mentions intent to gain in defining theft. Hence, intent to gain is the specific criminal intent in theft. If the Code uses the word purpose in defining a felony, the specific criminal intent is the purpose for which the felony must be committed. Article 134a of the Code employs the phrase for purpose of seizing or diminishing state power in defining coup d'etat. Hence, the specific criminal intent of coup d'etat is intent to seize or diminish state power. Implied criminal intent is not expressly stated but can be inferred from the criminal act described in Book 2 if Book 2 of the Code does not expressly reveal the specific criminal intent which is required to commit a felony. The criminal act and the criminal intent pertains to the same act. Article 249 does not expressly state the specific criminal intent for homicide. Since killing is the actus reus in homicide, intent to kill shall be considered as its specific criminal intent. General criminal intent. Dolo is the general intent found in Article 4, Book 1 of the Revised Penal Code, which is an essential element of every intentional felony. However, if the crime is culpable felony, there are only two elements: the criminal act and culpa. Article 249, Homicide. Any person who, not falling within the provisions of Article 246, shall kill another without the attendance of any of the circumstances enumerated in the next preceding article shall be deemed guilty of homicide and be punished by reclusion temporal. General criminal intent. Dolo is a general intent found in Article 4, Book 1 of the Revised Penal Code, which is an essential element of every intentional felony. However, if the crime is culpable felony, there are only two elements, the criminal act and culpa. In addition to the specific criminal intent, the commission of criminal act must be accompanied with evil intent, the mens rea, required to commit a felony in a combination of the evil intent and specific criminal intent. Hence, to be held liable for homicide, the killing must be accompanied with evil intent to kill. For example, killing a victim in the exercise of self-defense is justified. Although the accused killed the victim with intent to kill, he is not criminally liable since he committed the act without evil intent. Mere existence of right to self-defense is not an evil act. In U.S. versus A. Chong, DR number L5272, March 19, 1910, the accused was acquitted because of mistake of fact principle, even though the evidence has shown that he attacked the deceased with intent to kill. United States versus Apego, which was established by the statement of the accused, "If you enter the room, I will kill you." Article 249 of the Revised Penal Code, homicide, shall be read in relation to Article 3. The accused was acquitted not because of the absence of intent to kill, but by reason of lack of general intent, or dolo or malice. Article 3 says, acts and omissions punishable by law are felonies. Felonies are committed not only by means of deceit, or dolo, but also by means of fault, culpa. There is deceit when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Consummation of crimes. To consummate the crime, what is important is the commission of the criminal act by means of the required mode, with a general and specific criminal intent. The commission of the intended act, or the accomplishment of the criminal objective, is not necessary to consummate the crime. In theft, the criminal act is the taking of personal property without consent of the owner, while the criminal intent is to gain. Taking personal property with intent to gain consummates the crime. Actual gain is not necessarily requisite to complete this crime. Thus, taking a check with intent to gain consummates the crime of theft. Failure to actually gain from the check because the check was not in cash due to stop payment order does not negate the consummation of this crime. Seizing a person for purpose of demanding ransom consummates the crime of kidnapping for ransom. Failure to actually receive ransom payment because of the timely apprehension of the accused does not negate the consummation of this crime. Public and armed uprising for purpose of removing Marawi City from the allegiance of the central government and its law, as shown by the raising of a flag, consummates the crime of rebellion. Failure to actually remove the city from the allegiance to the government and its laws because of military operation does not negate the consummation of this crime. Felony and offense. The essential differences between a crime under special law and a felony are as follows. In addition to the specific elements of a felony, this crime must be committed by means of dolo, which is its general element. In crime under special law, dolo or malice is not an element unless it expressly says so, such as planting of evidence, and the provision in Book 1 of the Revised Penal Code are applicable to felonies defined in Book 2 and not to crimes under special laws. However, these provisions may apply to crimes under special law in a supplemental character. Voluntariness. The word voluntary, found in the Old Penal Code, is defining a felony, was eliminated in Article 3 of the Revised Penal Code. However, despite such elimination, voluntariness remains an element of a felony. Voluntariness is an essential element of crime. That's People versus Upuran, March 17, 2004. Whether it is committed by means of dolo or culpa, or classified as malum inse or malum prohibitum, to be considered a crime, the act must be committed with freedom and intelligence. In addition to voluntariness, intentional felony must be committed with dolo, malice, culpable felony with culpa, and mala prohibita under special laws with intent to perpetrate the act or with specific intent, such as animus possidendi in illegal possession of firearm. General element. Felonies are committed not only by means of deceit, dolo, but also by means of fault, culpa. There is deceit, malice, when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Culpa, imprudence indicates a deficiency in action. Negligence indicates a deficiency in perception. If a person fails to take the necessary precaution to avoid injury to person or damage to property, there is imprudence. If a person fails to pay proper attention and to use due diligence in foreseeing the injury or damage impending to the cost, there is negligence. Negligence usually involves lack of foresight. Imprudence usually involves lack of skill. Reckless driving. X, recklessly driving his car, bumped another vehicle, killing A and causing slight physical injuries to B. The office of the prosecutor filed two information, one charging X for reckless imprudence resulting in homicide and damage to property, and another reckless imprudence resulting in slight physical injuries. X pleaded guilty to reckless imprudence resulting in slight physical injuries and filed a motion to quash information regarding reckless imprudence resulting in homicide and damage to property on the ground of double jeopardy. Shall the court grant the motion? There are two views on whether culpa is a crime or just a mode of committing a crime. The first view, culpa under Article 3 of the Revised Penal Code is not a crime, but just a mode of committing a crime. Applying this rule, there are three crimes committed: reckless imprudence resulting in homicide, reckless imprudence resulting in damage to property, and reckless imprudence resulting in slight physical injuries. However, single reckless act resulting in homicide and damage to property is a complex crime. That's in Angeles versus Jose, November 24, 1954. But the slight physical injuries that resulted from the same recklessness shall be treated as a separate crime. Since this is a slight felony, it cannot be made a component of a complex crime. Under this view, the motion to quash shall be denied because reckless imprudence resulting in slight physical injuries and the complex crime of reckless imprudence resulting in homicide and damage to property are separate crimes. Hence, the conviction of the first is not a bar to the continued prosecution of the second. Second view, reckless imprudence under Article 365 is a single quasi-offense by itself and not merely a means to commit another crime. Hence, conviction or acquittal of such quasi-offense bars subsequent prosecution for the same quasi-offense, regardless of its various consequences. Yet the essence of the quasi-offense of criminal negligence under Article 365 of the Revised Penal Code lies in the execution of an imprudent or negligent act that, if intentionally done, would be punishable as a felony. Thus, the law penalizes the negligent or carelessness act, not the result thereof. The gravity of the consequence is only taken into account to determine the penalty. It does not qualify the substance of the offense, and as the careless act is single, whether the injurious result should affect one person or several persons, the offense criminal negligence remain one and the same, and cannot be split into different crimes and prosecution. Lifted from or asked in 1968, 1952, 1959, 1961, and 2013 bar exams. Under this view, the motion to quash shall be granted because reckless imprudence resulting in homicide, damage to property, and slight physical injuries constitute a single crime. Hence, the conviction of a culpable felony involving slight physical injuries is a bar to the continued prosecution of the same culpable felony involving homicide and damage to property. Article 365, Imprudence and Negligence. Any person who, by reckless imprudence, shall commit any act which, had it been intentional, would constitute a grave felony shall suffer the penalty of arresto mayor in its maximum period to prison correctional in its medium period. If it would have constituted a less grave felony, the penalty of arresto mayor in its minimum and medium period shall be imposed. If it would have constituted a light felony, the penalty of arresto menor in its maximum period shall be imposed. Any person who, by simple imprudence or negligence, shall commit an act which would otherwise constitute a grave felony shall suffer the penalty of arresto mayor in its medium and maximum periods. If it would have constituted a less serious felony, the penalty of arresto mayor in its minimum period shall be imposed. When the execution of the act covered by this article shall have only resulted in damage to the property of another, the offender shall be punished by a fine ranging from an amount equal to the value of said damages to 3 times such value, but which shall in no case be less than 25 pesos. A fine not exceeding 200 pesos and censure shall be imposed upon any person who by simple imprudence or negligence shall cause some wrong which, if done maliciously, would have constituted a light felony. In the imposition of these penalties, the courts shall exercise their sound discretion without regard to the rules prescribed in Article 64. The provisions contained in this article shall not be applicable. Number 1. When the penalty provided for the offense is equal to or lower than those provided in the first 2 paragraphs of this article, in which case the court shall impose the penalty next lower in degree than that which should be imposed, in the period which they may deem proper to apply. Number 2. When by imprudence or negligence, and with violation of the automobile law, the death of a person shall be caused, in which case the defendant shall be punished by prison correctional in its medium and the maximum periods. Reckless imprudence consists in voluntary, but without malice, doing or failing to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time, and place. Simple imprudence consists in the lack of precaution displayed in those cases in which the damage impending to be caused is not immediate nor the danger clearly manifest. The penalty next higher in degree to those provided for in this article shall be imposed upon the offender who fails to lend on the spot to the injured parties such help as may be in his hands to give. Falsification of document. The designation of the felony committed by the accused as falsification of public document through reckless imprudence is incorrect. Such designation implies that reckless imprudence is not a crime in itself, but simply a modality of committing it. Quasi-offenses under Article 365 of the Revised Penal Code are distinct and separate crimes, and not a mere modality in the commission of a crime. Hence, the crime should have been designated as reckless imprudence resulting in falsification of public documents. Sevilla v. People, August 13, 2014. Dolo. Malice or dolo is an essential element of malum in se. Malice is not material in malum prohibitum and culpable crime. In intentional felony, the concurrence of freedom, intelligence, and intent make up the criminal mind behind the criminal act. Thus, to constitute a crime, the act must generally and in most cases be accompanied by a criminal intent. Actus non facit reum, nisi mens sit rea. No crime is committed if the mind of the person performing the act complained of is innocent. People v. Ojeda, June 3, 2004. Criminal intent or dolo is an element of usurpation of function punishable under the Revised Penal Code for being a malum in se. This crime is being punished because it is wrong in nature. In sum, the law is concerned on the penalization of an evil or malicious act. Thus, lack of malice or criminal intent of the offender is a defense in the prosecution of malum in se. In Ruzol v. Sandigan Bayan, April 17, 2013, there is no showing that the mayor possessed that criminal mind when he issued the subject permits to transport salvage forest products and to regulate and monitor these products in order to avert the occurrence of illegal logging in the area. He is not liable for usurpation of function of the DNR because of good faith. Criminal intent or dolo is not an element in illegal possession of loose firearm, punishable under a special law for being a malum prohibitum. This crime is being punished not because it is wrong in nature, but simply because it is prohibited by law. Therefore, the law is concerned on the penalization of an act of defiance and not on an evil or malicious act. So, lack of malice or criminal intent of the offender is not a defense in the prosecution of malum prohibitum. Also, good faith or belief that the security agency secured license to possess firearm is not a defense in illegal possession of loose firearm filed against a security guard. Presumption of malice. The general criminal intent, malice, is presumed from the criminal act, and the absence of any general intent must be proven by the accused. In Chong's case, the accused was able to rebut the presumption of general criminal intent or malice. Generally, a specific intent is not presumed. Its existence, as a matter of fact, must be proven by the state just as of any other essential element. This may be shown, however, by the nature of the act, the circumstances under which it was committed, the means employed, and the motive of the accused. However, there are other specific intents that are presumed. If a person died due to violence, intent to kill is conclusively presumed. Intent to gain is presumed from taking property without consent of the owner. Malum prohibitum committed with malice. An act may be malum in se and be at the same time malum prohibitum if it is punishable under a special law, and yet malice is an element thereof. For example, planting of evidence is malum prohibitum since it is punishable under RA 9165, and yet Section 21 thereof requires malice as an element of this crime. Since good faith or lack of malice is a defense in this crime, it partakes of the character of malum in se. Felony classified as malum prohibitum. Intentional felony under the revised penal code is committed by means of dolo. Since dolo or malice is an element of intentional felonies, they are mala in se. However, there is an exemption. Technical malversation is an intentional felony, and yet the Supreme Court declared it as a malum prohibitum. In Isidro versus People, November 14, 2012, the mayor who applied 10 boxes of food appropriated for feeding program to the beneficiaries of shelter assistance program is liable for technical malversation. Mayor's act, no matter how noble or minuscule the amount diverted, constitute the crime of technical malversation. Criminal intent is not an element of technical malversation. The law punishes the act of diverting public property earmarked by law or ordinance for a particular public purpose to another public purpose. The offense is malum prohibitum, meaning that the prohibited act is not inherently immoral, but becomes a criminal offense because positive law forbids its commission based on considerations of public policy, order, and convenience. It is the commission of an act as defined by the law and not the character or effect thereof that determines whether or not the provisions has been violated. Hence, malice or criminal intent is completely irrelevant. Dura lex sed lex 2015 bar exam. Mistake of fact. Mistake of fact may negate specific element of a crime or dolo, or may be a source of mitigating circumstance. Negating specific element. The gist of theft is the intent to deprive another of his property in a chattel, either for gain or out of wantonness or malice to deprive another of his right in the thing taken. This cannot be where the taker honestly believes the property is his own or that of another, and that he has the right to take possession of it for himself or for another, for the protection of the latter. However, the belief of the accused of his ownership over the property must be honest and in good faith, and not a mere sham or pretense. If the claim is dishonest, a mere pretense, taking the property of another will not protect the taker. Gaviola versus People, January 27, 2006. This belief of ownership as a defense in theft is in accordance with the mistake of fact doctrine from 2012 bar exam. 5 laborers were hired by Manuel Diong to harvest coconuts from a plantation which he told them belonged to him. Unknown to them, the ownership of the land was in dispute. The laborers are not liable for theft because mistake of fact negates intent to gain, which is an element of theft. Negating dolo. Mistake of fact may negate dolo. It is a complete defense provided that the following requisites are present. Number 1, that the acts done would have been lawful had the facts been as the accused believed them to be. Number 2, that the mistake of fact is not due to negligence. 3, the mistake is not accompanied with criminal intent of the offender. The Supreme Court in several cases had applied the mistake of fact doctrine, which allowed the accused who committed a crime on a mistaken belief to enjoy the benefits of the justifying circumstance of self-defense. Defense of person in right. U.S. Chong case. U.S. Bautista, August 17, 1915, defense of owner. United States versus Apego, performance of duty. People versus Mamasalaya, the exempting circumstance of the obedience of an order of superior officer. People versus Beronila, or death under exceptional circumstance. The Revised Penal Code by Luis Reyes. Self-defense. In Chong, the accused who believed that the victim was a robber and that his life was in danger because of the commencement of unlawful aggression against him was acquitted due to mistake of fact doctrine in relation to the rule on self-defense. The act would have been justified had the existence of unlawful aggression been as the accused believed it to be. The mistake is not due to negligence since he tried to validate the identity of the victim. His intent is not unlawful because he was just honestly exercising his right to self-defense. Performance of duty. Iniyap Yuko versus Sandigan Bayan. Police authorities who manned a checkpoint because of the information that there was armed rebels on board a vehicle have the duty to validate the information, to identify them, and to make a bloodless arrest unless they were placed in real mortal danger. If they shot the suspected vehicle, which did not stop after having been flagged down, and killed the occupants therein, who turn out to be unarmed civilians, they are liable for multiple homicide. The mistake of fact principle is not applicable since there is negligence or bad faith on their part. In People versus Owanis and Galanta, the accused who believe that the sleeping victim is the notorious criminal to be arrested by them were held guilty of murder for shooting him, since the mistake of fact principle in relation to performance of duty is not applicable. The second element is not present since they did not ascertain first his identity despite the opportunity to do so. The first element is not also present since the killing of the victim believed to be a criminal was not a necessary consequence of the due performance of duty of the accused as police officers. However, the accused are entitled to the privileged mitigating circumstance of incomplete performance of duty. Defense of property. The accused mistakenly killed a thief in the toilet who turned out to be his girlfriend. In mistake of fact, which negates dolo, it is an important requisite that the act done would have been lawful had the fact been as the accused believed them to be. If there was really an intruder inside the toilet, the invasion would be considered as unlawful aggression against his property, which would allow him to use reasonable means to repel it in accordance with the self-help doctrine under Article 249 of the Civil Code and defense of property under Article 12 of the Revised Penal Code. However, the means employed by him, firing shots through the toilet door, is not reasonable. Hence, he is only entitled to privileged mitigating circumstance of incomplete defense of property. People versus Narvaez. In total, the act would have been attended by the privileged mitigating circumstance of incomplete justification had the facts been as the accused believed them to be. Irresistible force. Mistake of fact principle can also be applied in relation to circumstance of lack of voluntariness, such as irresistible force or uncontrollable fear. In total, the accused will not be held criminally liable for the result not intended when there is mistake of fact constituting an involuntary act. For example, A poked something at B and threatened to shoot him if he will not shoot the dog. Honestly believing that his life is in danger, B shot the dog, not knowing that A was merely poking a stick at him. B is not liable for malicious mischief because of the mistake of fact principle. B would have been exempt from criminal liability had the existence of irresistible force been as the accused believed it to be. Death under exceptional circumstance. Death under exceptional circumstance is similar to the mitigating circumstance of passion, considering that a person who killed his wife under exceptional circumstance under Article 247 is acting in a justified burst of passion. People versus Gonzalez. In several cases, the Supreme Court appreciated mitigating circumstance of passion, even if the acts causing the obfuscation was not true or established, as long as it was honestly and reasonably believed by the accused to be true. If the principle of mistake of fact had been applied to justify the acts of the accused, to exempt him from liability or to mitigate his liability, there is no reason why it should not be made applicable to a case involving absolutory cause under Article 247 in the light of the time-honored principle of pro reo. 2011 bar. Article 247 under the Revised Penal Code. Death are physical injuries inflicted under exceptional circumstances. An illegally married person who, having surprised his spouse in the act of committing sexual intercourse with another person, shall kill any of them or both of them in the act or immediately thereafter, or shall inflict upon them any serious physical injury, shall suffer the penalty of destierro. If he shall inflict upon them physical injuries of any other kind, he shall be exempt from punishment. These rules shall be applicable under the same circumstances to parents with respect to their daughters under 18 years of age and their seducer, while the daughters are living with their parents. And a person who shall promote or facilitate the prostitution of his wife or daughter, or shall otherwise have consented to the infidelity of the other spouse, shall not be entitled to the benefits of this article. Motive. In a criminal case, the prosecution must prove the elements of a crime and the identity of the person who committed it. Proof of motive will not establish the elements, but it will help the prosecution in showing that the accused committed the crime. The identity of the culprit, which is an essential requisite to convict the accused, is usually established through positive identification of the witness. However, if there is doubt as to the identity of the culprit, showing motive to the accused for committing the crime will help establish his direct link to the commission thereof. The lack or absence of motive for committing a crime does not preclude conviction where there are reliable witnesses who fully and satisfactorily identify the accused as the perpetrator of the felony. Comer versus People, September 11, 2013. Motive and criminal intent. Motive and criminal intent are distinguished as follows. Motive is the moving power which impels a person to do an act for a definite result. Intent is the purpose for using a particular means to bring about a desired result. 2. Motive is not an essential element of a crime, hence, it need not be proven for purposes of conviction. Motive is essential only when there is doubt as to the identity of the culprit or when the evidence is circumstantial or inconclusive. Criminal intent renders an act a felony. It is the general element of all intentional felony. Proof of motive is required. Proof of motive becomes a crucial consideration in a criminal prosecution. 1. Where there is doubt as to the identity of the culprit. 2. Where the evidence is circumstantial or inconclusive, and there is some doubt on whether a crime has been committed or whether the accused has committed it. People versus Assis, Trinidad versus People. Proof of motive and circumstantial evidence on hand may establish the guilt of the accused beyond any doubt. People versus Obosa. 3. Where the act committed gives rise to variant crimes and there is the need to determine the proper crime to be imputed to the offender. 4. Where it forms an essential element of the offense, such as in cases of libel or slander or malicious mischief. Diva and Diva. DR number L22946. 2013, 2011, 1999 bar exams. If the accused committed variant crimes, the identification of motive is important to determine the crime of which the accused can be held liable. If a person burned a building and as a consequence the owner thereof died, his motive will determine whether the crime committed is murder or arson with homicide. Proof of motive is not required. Proof of motive is not necessary in a criminal prosecution. 1. Where the accused has been positively identified as the assailant, People versus Ferreira, or where his participation is shown. 2011 bar exam. 2. Where the criminal act did not give rise to variant crimes. 3. Where the crime involved is culpable felony or offense or malum prohibitum. Presence of motive indicates criminal intent. Motive is indicative of criminal intent. The accused had been conducting their business at a loss for nearly 18 months. There is a strong motive to burn their properties to make an insurance claim. The success of their crime of arson meant that they would receive about twice the value of their stock of goods and thus convert a losing investment into a profitable one. In this case, motive is indicative of their criminal intent. U.S. versus Go Fu Sui, GR number 8217, September 6, 1913. Lack of motive is not indicative of innocence. Lack of motive is not proof of innocence. 1978 bar exam. Lack of motive for committing a criminal act does not necessarily mean that there is none. Motive is unknown because it is found in one's conscience, which is not accessible to human observation. Moreover, an extreme moral perversion may lead a man to commit a crime without a real motive but just for the sake of committing it. People versus Paguntalan. People versus Teneo. Thus, lack of motive can result in conviction where the crime and the participation of the accused are shown. 2011 bar exam. Classification of felonies. Under Article 9 of the Revised Penal Code as amended by RA number 10951, felonies are classified into grave, less grave, and light felonies. Grave felonies are those to which the law attaches the capital punishment or penalties which any of their periods are afflicted. Example, reclusion perpetua, reclusion temporal, prison major, or a fine exceeding 1.2 million. Less grave felonies are those which the law punishes with penalties which in their maximum period are correctional. Example, prison correctional, arresto mayor, or a fine not less than 40,000 but not exceeding 1.2 million. Light felonies are those infractions of law or the commission of which the penalty of arresto menor or a fine not exceeding 40,000 or both is provided. However, under Article 26, a fine not less than 40,000 but not exceeding 1.2 million shall be considered a correctional penalty. Idealistically, the penalty for a light felony should be a light penalty. However, RA 10951 has retained the phrases not exceeding in Article 9 and not less than in Article 26, despite the fact that they provide a legally absurd situation where light felony can be punished by a correctional penalty. In reckless imprudence resulting in damage to property, where the amount of the damage is 13,333, the highest penalty imposable is fine of 40,000. This is a light felony in accordance with Article 9, but the fine is not exceeding 40,000. On the other hand, the penalty is correctional in accordance with Article 26 because the fine is not less than 40,000. A light penalty of fine must be less than 40,000. In People v. U. High, August 15, 1956, the Supreme Court was confronted with the issue of prescription of a light felony, which is punishable by a correctional penalty, according to the highest tribunal. Since the issue is prescription of crime and not penalty, Article 9 on classification of felonies shall apply. Applying U. High principle by analogy, if the issue is prescription of penalty, Article 26 on classification of penalty shall apply. Under Article 90, the prescriptive period of a light felony is 2 months. Under Article 9, a crime punishable by a fine exactly 40,000 is a light felony because it is not less than 40,000. Hence, the period of prescription for this crime is 2 months. Under Article 92, the prescription period of correctional penalty is 10 years. Under Article 26, a fine of exactly 40,000 shall be considered as correctional penalty because fine is not exceeding 40,000. Hence, the period of prescription of this penalty is 10 years. Light felony is punishable except attempted or frustrated light felony unless it is a crime against property or person, Article 7 of the Revised Penal Code, and light felony committed by an accessory one can be charged for a light felony or of attempted theft of 2,000 pesos. Theft is a crime against property and thus it is punishable even though it is not consummated. 1977 bar. Article 9. Grave felonies, less grave felonies, and light felonies. Grave felonies are those to which the law attaches the capital punishment or penalties which in any of their periods are afflictive in accordance with Article 25 of this code. Less grave felonies are those which the law punishes with penalties which in their maximum period are correctional in accordance with the above-mentioned article. Light felonies are those infractions of law for the commission of which the penalty of arresto menor or a fine not exceeding 200 pesos or both is provided, which is now 40,000 or both is provided. Article 26. When afflictive correctional or light penalty, a fine, whether imposed as a single or as an alternative penalty, shall be considered an afflictive penalty if it exceeds 1,200,000 pesos, a correctional penalty if it does not exceed 1,200,000 pesos, but is not less than 40,000 pesos, and a light penalty if it be less than 40,000 pesos. Elements of criminal liability. The time-respected doctrine, he who is the cause is the cause of the evil caused, is a rationale in Article 4 of the Revised Penal Code, which provides that criminal liability shall be incurred by a person committing a felony, delito, although the wrongful act done be different from that which he intended. People versus ULEP. Intentional felony. Article 4 of the Revised Penal Code is only applicable if the accused committed an intentional felony. Article 4. Criminal liability. Criminal liability shall be incurred 1. By any person committing a felony, delito, although the wrongful act done be different from that which he intended. 2. By any person performing an act which would be an offense against person or property, were it not for the inherent impossibility of its accomplishment, or on account of the employment of inadequate or ineffectual means. Suicide. Suicide is not an intentional felony. Hence, a pregnant woman who attempted to commit suicide is not liable for abortion by reason of the consequent death of her fetus. 2012 bar exam. But killing one's girlfriend in accordance with a suicide pact constitute the crime of assistance to suicide under Article 253 of the Revised Penal Code. This crime is committed by a person who lends his assistance to another to the extent of doing the killing himself. 2008 bar exam. Article 253, giving assistance to suicide. Any person who shall assist another to commit suicide shall suffer the penalty of prison mayor if such person lends his assistance to another to the extent of doing the killing himself. He shall suffer the penalty of reclusion temporal. However, if the suicide is not consummated, the penalty of arresto mayor in its medium and maximum periods shall be imposed. Practicing medicine without license. Practicing medicine without license is an offense punishable under special law, but it is not an intentional felony within the meaning of Article 4. Hence, a quack doctor who killed his patient while treating him is only liable for reckless imprudence resulting in homicide. People versus Carmen. Kidnapping. As a rule, Article 4 is only applicable if the act committed by the accused constitute an intentional felony and not an offense under special law. However, there is an exemption. The concept of kidnapping under Section 3 of RA 10883 is the same as that of theft and robbery. People versus Sia. Although not punishable under the Revised Penal Code, it can be treated as an intentional felony within the meaning of Article 4. Thus, if after taking the motor vehicle, the kidnapper accidentally bumped and killed a bystander, the crime committed is simple kidnapping and homicide, since kidnapping is the proximate cause of the death of the victim. The accused shall incur criminal liability for homicide in addition to kidnapping, although his intention is merely to commit kidnapping. Article 4. Criminal liability shall be incurred by any person committing a felony, delito, although the wrongful act done be different from that which he intended. 2. By any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment, or on account of the employment of inadequate or ineffectual means. Error in personae. Error in personae means mistake of identity. In error in personae, a person is criminally responsible for committing an intentional felony, although the actual victim is different from the intended victim due to mistake of identity. 1949 and 2017 bar exam. Aberratio ictus or error in personae carries the same gravity as when the accused zeroes in on his intended victim. People versus Pinto. For example, X waited in ambush for A to kill him. He saw B a few meters away, and believing B to be A, he fired upon and killed B, whom he had no intention of hurting. X shall incur criminal liability for killing B because of the error in personae principle. In mistake of fact, the mistake pertains to the elements of justifying circumstance, exempting circumstance or absolutory cause, such as the existence of unlawful aggression while in error in personae, the mistake merely pertains to the identity of the victim. In mistake of fact, the accused committed the act without dolo, hence he is not criminally liable, and because of such mistake, the justifying circumstance, exempting circumstance, or absolutory cause shall be considered in his favor. In error in personae, the accused acted with dolo, hence he shall incur criminal liability for killing or injuring a victim, although this victim is different from the intended victim. Aberratio ictus. Aberratio ictus means mistake of blow. In aberratio ictus, a person is criminally responsible for committing an intentional felony, although the actual victim is different from the intended victim due to mistake of blow. 2015 bar exam. Non-felonious act. If the act which caused injuries or death of a third person by reason of mistake of blow is not an intended felony, Article 4 on aberratio ictus shall not apply. Committing an act in self-defense or in the exercise of right to defense possession of property. People v. Bindoy. Or causing death or injuries under exceptional circumstance, People v. Arakel, is not an intentional felony. In committing such non-felonious act, the perpetrator is not liable for the injuries or death of the third person who was hit by reason of mistake of blow. Article 4 is not applicable because the perpetrator is not committing an intentional felony. He is exempt from criminal liability because of the circumstance of accident. But if the perpetrator is reckless in committing the non-felonious act, he can be held liable for reckless imprudence resulting in homicide or physical injuries. X prevented A from having a bloody encounter with his father. B tried to remove the hands of X, who was holding A. X pulled the hands of B, causing her to fall over C, her baby. Preventing A from having a bloody encounter with his father and pulling the hands of B are not intentional felonies. X is just exercising his right to defend his father, hence X is not criminally liable for the death of the baby. Article 4 on aberratio ictus is not applicable. X attacked A. While the assault was in progress, B grabbed the weapon from X. As a consequence, C, a passerby, was accidentally hit by the weapon. X is responsible for the injuries sustained by A and C. The act of X in attacking A is an intentional felony. Hence, X is responsible for the injuries sustained by C, which are the direct, natural, and logical consequence of the felony committed against A. The act of B in grabbing the weapon from X is not an intentional felony. It is a justified act due to the circumstance of defense of stranger. Therefore, B is not responsible for the injuries sustained by C. Article 4 on aberratio ictus shall not apply since B is not committing an intentional felony. B is exempt from criminal liability for the injuries of C due to circumstance of accident. Intent to kill. In aberratio ictus, there are at least two victims, the intended victim and the third person, who was hit by reason of mistake of blow. Even though there is intent to kill the target victim, the court should still make an assessment if there is intent to kill the third person, who was hit by reason of aberratio ictus. If the third person died, intent to kill is conclusively presumed. Therefore, the crime committed against the third person is homicide or murder. People v. Adiano. If the third person merely suffered injuries and there is intent to kill, the crime committed is attempted or frustrated homicide or murder. Intent to kill the third person can be established if the accused is aware of the possibility of hitting others in the process of killing the target victim. Such awareness is a circumstantial evidence of intent to kill the third person. People v. Julio Guillen, and People v. Flora and Flora, and People v. Talampas. If the third person merely suffered injuries and there is no intent to kill, the crime committed against him is merely physical injuries. The following circumstances negate intent to kill. 1. The accused is not aware of the presence of the third person, or there is no showing of such awareness. 2015 bar exam. Number 2. The victim was hiding. People versus Violin. Number 3. The accused did not kill the third person despite opportunity to do so. X, with intent to kill, shot A, who sustained mortal wounds. B was hit by reason of Aberratio ictus and died as a consequence. C was also hit by reason of Aberratio ictus and suffered injuries, which healed after 2 weeks. The crime committed against A is frustrated homicide since he committed the act with intent to kill. The crime committed against B is consummated homicide since B died and intent to kill is conclusively presumed. The crime committed against C is less serious physical injuries. There is no showing that X is aware of the presence of C when he shot A. Hence, intent to kill was not established. X is liable for a compound crime of homicide with attempted homicide and serious physical injuries since the crimes were produced by single act.